Hi, my name is J.D. Reese, and I serve as the manager of the criminal history system within the Missouri State Highway Patrol Criminal Justice Information Services Division. This past legislative session, the Missouri General Assembly passed Senate Bill 588, which modifies the provisions to have a criminal record closed. We've received a lot of questions from the general public on this bill, and consequently, we decided to make this video to explain what Senate Bill 588 does, and perhaps more importantly, what Senate Bill 588 does not do. First of all, Senate Bill 588 modifies the existing sections dealing with expungement by modifying the provisions of Section 488.650 and Section 610.140 of the Missouri Revised Statutes. It greatly increases the number of offenses that are eligible, while at the same time modifying how the expungement process works. Probably the most important thing to understand about this legislation is that it does not remove the record completely. Even though Senate Bill 588 uses the term expungement, in reality, it only closes the record pursuant to Section 610.120. While this will remove the record from being available to the general public, there are many agencies that have statutory authority to access closed record information. In particular, the record is still available to all criminal justice agencies, as well as schools, state licensing agencies, and many agencies that provide care for children, the elderly, or disabled. A summary of agencies that currently have the authority to access closed record information is included under Section 610.120. The next thing to consider is the disposition of the offense that you're wanting to expunge or close. If your offense is already closed, then there is no added benefit to applying for an expungement under this legislation. For example, if you were arrested and charges were not filed, charges were dismissed, you were found not guilty, or you received a suspended imposition of sentence and successfully completed your probation, then your record is already closed. If you are unsure of the disposition of your case, you can run a criminal history background check on yourself. Further information about how to complete a criminal background check can be found via the Missouri Automated Criminal History site, MOCS, at www.machs.mo.gov. In addition, this legislation does include some restrictions on what offenses can be expunged or closed under Senate Bill 588. Any dangerous felonies and misdemeanors are excluded, including intoxication-related traffic or boating offenses. For a full list of excluded criminal offenses, you can view Senate Bill 588 in its entirety at the Missouri General Assembly website at www.senate.mo.gov. Lastly, there are limits on the number of offenses an individual can have expunged or closed. An individual is limited to the expungement or closing of one felony conviction or two misdemeanor or ordinance convictions during their lifetime. The only exceptions to this is if the offenses were all charged as counts in the same indictment or information or were committed as part of the same course of criminal conduct. If this is the case, then all offenses on the petition will only count as one conviction using the highest level offense. This can quickly get confusing, so here are some examples. Let's say you are an individual that has one felony conviction in Cole County, a misdemeanor conviction in Jackson County, and another misdemeanor conviction in St. Louis County. As long as all three offenses are eligible to be closed and all other requirements are met, you could file a separate petition in each court to have all three offenses closed. Once this occurs, you would have exhausted the limits of this legislation and you would not be eligible to close any additional records under this section. However, let's say you're an individual that has a felony conviction and two misdemeanor convictions in Cole County that were all charged as part of the same indictment. If these offenses are eligible for closure and all other requirements are met, then you could file one petition to cover all three offenses. Since your offenses were all charged as part of the same course of criminal conduct, your expungement would only count as one petition for the highest level offense, in this case, a felony. Consequently, you would still be eligible to apply for up to two more expungements of misdemeanor level offenses prior to exhausting the limit. Senate Bill 588 also creates a series of other requirements that must be met in order to be eligible for an expungement. The first of these requirements is a time requirement that states if the offense you're applying to close is a felony, then you must wait 7 years from the date that you completed any authorized disposition before applying for expungement. This means that 7 years must have passed from the time you completed your confinement, probation, or parole. Closures associated with misdemeanors, ordinances, and infractions operate the same way, with the exception that the time requirement is lowered to 3 years from the completion of disposition. The second requirement looks at any subsequent offenses you may have. This requirement ensures that you have not been found guilty of any other misdemeanor or felony, not including a traffic violation, for at least 7 years if the offense is a felony, and 3 years if the offense is a misdemeanor or municipal offense. Requirement number 3 necessitates that you must also have satisfied all obligations relating to the disposition, including payment of any fines or restitution. The fourth requirement will look at any pending charges you may have. If you have any pending charges, then you are automatically disqualified from applying for record closure under this bill. Lastly, the judge hearing your case will look at your habits and conduct to ensure that you are not a threat to public safety and that the closure of your record is consistent with the public welfare and interests of justice. Senate Bill 588 becomes effective January 1st, 2018. Hopefully this short video has assisted you in understanding what a record closure under Senate Bill 588 does. Again, probably the most important thing to remember about this legislation is that it does not remove your record completely. If you apply for expungement under this legislation, expecting to have your record destroyed, then you will likely end up disappointed. However, for those individuals that do not work or expect to work for an agency that has access to close records, then this legislation could be a tremendous benefit.